My name is Maya. I'm the editor-in-chief of the NYU Law Review. Thank you all so much for coming, and for those of you who've come to our previous panels, thank you for coming to those. We've been so excited to host them with the Center on Race, Inequality, and the Law, and to have such amazing panelists with us. We will be publishing select essays from these panels on the Law Review online, so you can watch out for those either on our website, or if you want to stay up to date on all of the Law Review pieces, you can subscribe to our newsletter. I will be sending out a link after this panel. You can also follow us on Twitter. Thank you so much for coming.
Thank you. Great, good afternoon. Thanks. And welcome to this third discussion in this series on the anatomy of racism and inequality in the law. I wanted to start by just thanking a couple folks in the room, a couple of entities, of course the Law Review, for helping to put this together, and then the Center on Race, Inequality, and the Law. These are important conversations to have, and they help us understand the source and the nature and the impact of racial inequality. And this is all with an eye towards developing strategies, legal and otherwise, to address and confront inequality. I'm super excited to have this panel and to participate. My name is Alexis Hoag, by the way. I'm a practitioner in residence uptown at Columbia for the Eric Holder Initiative for Civil and Political Rights. And at one point, I was a student here, so it's nice to be back. Today, we'll be examining racial inequality in the criminal legal system, and that nomenclature is purposeful. It's not a criminal justice system yet. And it's an honor for me to discuss these issues with our four experts, who I will introduce briefly so that we can start hearing from them. To the very far left, we have ReNika. She is recently named the director of the ACLU's Racial Justice Project, and she's a longtime civil rights attorney, having come from the New York AG's office. I want to welcome back to NYU with a purple tie, repping. Michael Pinard is an NYU law graduate. He's a Francis and Harriet Engelhardt Professor of Law at the University of Maryland, and he also co-directs the clinical programs there. And he started his career as a public defender. Vincent, right next to me, Southerland, many of you know him. He's the inaugural executive director of the center here, and he's a former civil rights attorney and a public defender. And then in the red necklace, we've got Christina Swarns. She's now the attorney in charge of the Office of Appellate Defender. She also started her career as a public defender and has worked at multiple levels of that system. And she successfully argued Buck versus Davis before the United States Supreme Court. So we are in for a real treat. Please join me in welcoming all of them. I'd like to open the discussion first by identifying the source, the root of inequality in our criminal legal system. And I want to move on to then talking about the contemporary manifestations of this inequality. And I want to end with areas for innovation, strategies to address and confront the issues that we identify. And of course, I want to open it up for questions. I think we're in here until about 2 o'clock. So ReNika, can we identify a source? Nicole Hannah-Jones in the New York Times points to 1619, the date that enslaved Africans were brought to the shores of the colony. Brian Stevenson tells us that slavery didn't end in 1865, it merely evolved. So where do we begin, and how did we get here?
Sure. So, I think when we think about the origins of this country, we recognize the role of slavery. And where I want to start is actually one of the earliest legal decisions where you see the intersection of race, criminal punishment, disparate sentencing, and slavery come together. And that comes to us. So there was in the Virginia colony, in the early days of the colonies, they essentially relied on for labor indentured servants. And so often, a lot of the work that had to be done was clearing of trees, clearing of land, and beginning of an agricultural society. And so this case involves 3 indentured servants, 2 white, 1 black, who worked for a wealthy farmer in the Virginia colony. And the 3 indentured servants had run away to Maryland and were captured and brought back by the farmer who held the contracts on those indentured servants. And so what we see is that they're brought to court for punishment by the farmer. And what the Virginia court does in this case is very explicitly identify the indentured servants based on their race. So it talks about the punishment of all three. It sentences all three of the indentured servants to whipping, 30 lashes, and it talks about the two white indentured servants. One it identifies as a Scotchman, the other it identifies as a Dutchman, and it essentially adds an additional year onto their term of indentured servitude to the farmer, and then it adds an additional 3 years of service of indentured servitude to the colony itself. But then for the third, for the indentured servant who was black, who they identify in the decision as a Negro, that person, his name is John Punch, is sentenced to a lifetime of servitude, a lifetime of slavery to that farmer. And you really see, I mean, this is the first we see of the first sentencing disparity, which we may talk about a little bit later. And there really isn't a precedent that we see, but we see that this person is treated very differently. And I think over the next 75 years, chattel slavery takes hold, racialized chattel slavery takes hold in the colonies, and we see the adoption and the codification of different treatment. So first, we see the adoption of slave codes, and those codes are really intended to do three things in terms of the protection of the institution of slavery, which has become the economic backbone of the new country. So these slave codes are intended to impose strong social and economic controls on slavery, and they're really intended to protect slaves from running away, to protect them from being able to resist and rebel, and to ensure their productivity as workers. And so we see that, and the slave codes are adopted throughout the colonies, so we see them from New York to the southern colonies, so this isn't just a southern phenomenon. And we really see, and I'm going to use, in 1740, South Carolina, following a large rebellion of enslaved people, South Carolina really beefs up its slave codes, and I think it offers an example of the ways in which it becomes a comprehensive state control over these slaves. And so what they're talking about is not just under pre-Civil War, generally speaking, the slave owners have a lot of power, and there's an assumption that the state is not going to have to impose punishments or controls. So really, a lot of that is rested with the slave owner himself. But they also utilize everyone, so there are slave patrols that are created, which are intended to capture runaway slaves. They're intended to terrorize and ensure that rebellions and resistance is not shown, and they're intended to impose discipline and punishment to ensure that workers are doing the work that they're supposed to do. And then the slave codes include all kinds of things in terms of not teaching slaves to read, not teaching, not allowing them to be economically self-sufficient. And it also imposes and presses into service everyone in the community. And that includes enslaved people themselves to be able to impose punishments. And so you see in the slave code that they can be required to execute punishments, whether that's whippings, it might include execution of another slave. And so the whole system is really pressed into service to suppress, to control, to be able to stop resistant enslaved people, to search them, to examine them, and you start to see the early stages of the police state that we know today. So I'll stop there.
Mm-hmm. Yeah. So already you've mentioned sentencing disparities in the very beginning, and this idea of slave patrols, which some scholars have then pointed to modern day policing and paroling as an unbroken thread from that time. And then already in the early development of the laws, there is an exception to servitude as punishment for crime. And so that's also very early on, and of course Ava DuVernay's 13th features that. Christina, I wanted to move next to you. Our early laws are so aspirational, right? This idea of due process and equal protection. And we have a hot mic?
Yes, yeah. I think I do, yeah.
And so much a part of this due process in the beginning is this right to counsel, and to have an advocate. And I don't know that our country has really even met that demand. It was, I think, a 1935 decision stemming out of the Scottsboro Boys trials, Powell versus Alabama, which said that criminal defendants charged with a capital crime must have counsel supplied to them. Gideon versus Wainwright in 1963, that again, indigent criminal defendants must have a government-provided attorney. Have we met that aspirational sort of charge?
Surely not. And I think building on what ReNika said, that there's a lot of reasons that we have not met the goal of providing poor people with the kind of counsel that they need and they deserve. But I think one of the big reasons is that we have not, as a country, reckoned or reconciled with the original sin of chattel slavery in this country and the implications, right, that continue to sort of reverberate through our society. As a public defender, as a person that runs a public defender office, I would say that we have three things happening at any given time. First and foremost, of course, is the resources issue, right? Every public defender's office struggles with an enormous number of cases and inadequate resources. Here in New York, we have far more than many of my peers across the country, but still, every day when I go to work, we are constantly at a battle between providing, everything that each of our current client needs without sacrificing the fact that there are, 200 more coming in the door behind us. And I have a limited number of lawyers with which to facilitate that. New York is, an embarrassment of riches, though, compared with other places across the country where the folks on this stage have litigated cases. Alexis, Vincent, and I litigated a case in stages, I think.
Yes.
In Arkansas, where our client was represented by a gentleman who had the contract to be the public defender for an entire county, one of two, and he had that contract meant he handled 60% of the cases for the entire county. That meant that he had in 1 year, the year our client was tried and condemned to death, he had 715 clients in 1 calendar year. He did 25 jury trials. And the good news is that was half of his legal practice, because 40% of his practice was dedicated to civil practice, to civil litigation. He was also the debt collector in town. So for half of his practice was 715 cases in 1993. Clearly none of those clients received adequate representation, including the one we represent. So, okay, first point, resources and numbers are constantly a challenge to folks doing indigent defense representation. That is immediately compounded, back to ReNika's point, with the reality that we live with, which is that we continue to be in a society where race is indelibly linked to crime and criminality. And that ultimately creates a tragic confluence of events between making very quick and very important decisions and having in your mind, even as a defender, right, this idea that blackness or brownness is equivalent to criminality. Mm-hmm. That plays out in dramatic effect, of course, in my case, the case that went to the United States Supreme Court, the Dwayne Buck case, where I represented Mr. Buck, was condemned to death after his own attorneys introduced in his defense an expert that testified that Mr. Buck was more likely to commit criminal acts of violence in the future because he was black. The jury finding of whether a person was likely to be a future danger is the prerequisite for a death sentence. So his own attorney not only provided the prerequisite finding for a death sentence, he made it based on the immutable characteristic of race, right? And not only do two lawyers put this on in the witness stand, put it on in a courtroom, right? There's a judge, there's a prosecutor, and everyone in this room sort of nods amiably. And it goes through round after round after round of appeal. And, it's not till we get to the United States Supreme Court that by some freak miracle, Justice John Roberts finally says, wait, there's something wrong with this, right? So this is another, right? So this is a way that these two things start to run into each other. And then the last piece of this is, right, and that's an example of explicit bias, but really the primary issue that we face, right, is implicit bias. Public defenders every day are making decisions very quickly about people with whom even the most well-intentioned, most idealistic have in their mind implicit biases. That's a phenomenon of our country that dates back to slavery. And study after study, we have the fortune of having an expert in implicit bias in the House, Professor Anna Roberts, but study after study show that when you're people making snap judgments, like in emergency room doctors, for example, when you're making very quick decisions under very high stress circumstances, race does factor in. And so in the emergency room context, emergency room doctors were found to be less inclined to give, not extra. they gave white patients more treatment than similarly situated Black patients. This is exactly what plays out every single day in public defenders' offices across the country, right? I am required to make a decision. How am I supposed to advocate for bail, or to what extent am I going to fight for bail? To what extent am I going to is this a person for whom I should be fighting for a plea, or I should be going to trial? Is this a person for whom a sentence of, time in prison is appropriate or not? All of those judgments are constantly influenced and undermined by this perceived link between race and criminal justice, and that feeds into, right, the sentencing disparities that ReNika talked about. So while we can all, and I am first in line to blame prosecutors for those disparities and police officers, the truth is that the defense bar and the indigent defense bar really has to play a role as well in addressing those issues to reform the criminal justice system and the disparities.
Thank you, Christina. But it's really every step of the way that race is impacting people's engagement with the criminal justice system, from the beginning with investigation, the charging decisions, the jury's decision, and then even looking within the capital context, the likelihood of being actually executed for the crime which you were convicted for. So race is playing a role at each of those steps. And I wanted to turn next to Michael. So we know that the impact of a criminal conviction, and often even mere contact with the criminal legal system, can have far-reaching implications for people of color. As a society, we went from incarcerating approximately 500,000 individuals in the mid 1900s to today, where we have over 2.2 million people incarcerated. We're leading the world, really, in that regard. And so much of that falls on Black and brown citizens. And so, Michael, can you speak about some of these collateral consequences, particularly within the education context and other areas?
So, yeah, thank you. Sorry, let me turn this on. And so I just wanted to, I was struck, Christina, when you said that, in your work at LDF and in other spaces, about how New York, right? You're in New York, and sometimes it's not until you leave New York that you realize, actually, comparatively speaking, how good things are here. And so it just reminded me, when I first moved to Baltimore in 2002, and I spent a summer I was teaching a criminal defense clinic my first year there, and I was spending the summer trying to see how do they do things in Baltimore. I was struck how easy it is to waive your right to an attorney in Baltimore. I mean, it is to this day very routine for people to stand up in court by themselves, to have to defend themselves. And also, just to follow up on your question about the prison population, there was a new study came out a couple of weeks ago about Maryland's prison population. So Maryland's prison population right now is 71% Black in a state that's 30% Black. It's the biggest gap between population of Black residents and the incarcerated population in the country, right? And so when you say something is worse than Mississippi, you know things really are at rock bottom, and that's where we are right now in Maryland with the prison population. All right, so with regard to education, I think it's really important to start the conversation with our youngest folks. Right? These are the folks who are in our public schools in this country. And so Black students are 15% of the public school population in this country, but comprise 31% of students who are referred to law enforcement or who are arrested in school, right? And so when we talk about criminalization, it doesn't just start in the neighborhood. Also, you think about it from the pre-K, right? There are all these studies out there that even in pre-kindergarten, black students are excluded from school more than anyone else. And think about the lessons that teaches these youngest, the youngest of us. All right, so black students in schools are suspended, expelled, referred to law enforcement for the same behaviors as white students, and particularly black girls, right, are actually disproportionately suspended, expelled from school, and referred to law enforcement. And for black girls, there's this phenomenon called attitude tickets, which really is about criminalization, right, and sort of gendered biases around criminalization and how are you supposed to act in school as a young girl or a young lady, but black girls are singled out for being criminalized in our schools. So when children are removed from schools, they are more likely to fall behind in their grade, they're more likely to drop out of school, they're more likely to engage the juvenile justice system and then the criminal justice system. So that's just on the suspension side, right? And when students are referred to law enforcement, right, law enforcement then has the discretion to move this case along to the prosecutor's office, who then has the discretion whether or not to bring charges against this young person. And disproportionately bring charges against black students and brown students, and then they're in juvenile court, and these findings are then reported back to the school, okay? So on the one hand, you have in-school behavior that's being criminalized that leads to removal from school, and then there's this other category called reportable offenses, okay? These are offenses that take place, or behaviors that take place off of school grounds, all right? So you could be at your local mall, all right? Two kids have a fight, there's an injury, there are certain offenses that law enforcement then has to report back to their schools, okay? This is not school behavior at all. The schools then have the discretion to exclude those students from school, okay? So you're criminalized for in-school behavior and out-of-school behavior. So I think it's important when we talk about these collateral consequences to start the conversations in our public schools, okay? Now, way after my day applying to college, I knew nothing about this Common App. I think we were just doing this like on stones when we were applying to college. But now there's this thing called the Common App, right? You probably know all about this, right? There you go, the Common App. I wasn't looking at you, just to be clear.
Right past me.
I squeezed right in that same
But
time
you
zone.
may remember when you applied, if you use this common application, it asks this question: have you ever been adjudicated guilty or convicted of a misdemeanor, felony, or other crime, right? You're applying to college, for the most part, you're 17, 18 years old. These applications are asking about your juvenile records, okay? So your juvenile records can actually disqualify you from college, right? You may not be able to get into college, let alone law school, even with a juvenile record, right? So that's a collateral consequence right there. Now, when you're in college, right, and it's important to also note that a lot of these collateral consequences, the laws around these collateral consequences, were enacted in the 1990s, right? During the war on drugs, during the tough on crime movements. And that's why so many of these collateral consequences really are specific to drug offenses, okay? So if you are a college student or a law school student and you have a student loan, if you are convicted of any drug offense, possession or sale, okay, you will then be disqualified from that loan, right? If it's a first offense, you're disqualified for a couple of years, then it builds up to permanent disqualification from this loan. So that's only about drug offenses. You could do anything else pretty much, right? And you will still keep that loan. So that's another collateral consequence, rather, focus on education. I guess I should stop there. We could talk about some other stuff later on.
And so much of the collateral consequences, particularly those tied to voting, are really stripping individuals, and again, this is mostly black and brown individuals, of citizenship and their ability to participate fully in society. I also want to turn to Vincent to talk about, Michael mentioned these developments in the criminal legal system in the 1990s. More recently, in the aughts, if I can call it that, there's been this engagement of using technology, algorithmic tools to monitor sort of recidivism rates, to predict certain indicators, to predict likeliness of people engaging in criminal activity. And can you talk about the unique sort of impact some of these more modern tools have had on populations of color?
Sure. So it strikes me that kind of the problems that we've heard from ReNika, Christina, and Michael are all things that folks have identified as like deeply problematic, of course, with the criminal legal system. One, a system that I don't think is actually broken, but functioning exactly the way it was designed. And of course ties race to criminality and dangerousness and affects the way people make decisions in these systems across the board at every stage of the system. And so in response to this understanding, this growing understanding that the system itself is fundamentally flawed and fundamentally problematic, there has been this growing turn to the use of algorithmic tools and technology to help try and eliminate or address and confront some of the biased and inequitable decision-making that happens in the criminal legal system. And these tools are kind of being developed and implemented at all stages of the system by all different types of actors in the system. So everything from police, using them for predictive policing techniques to try and forecast where a crime might take place or who might be the victim or perpetrator of a particular crime. By judges and prosecutors who are relying on them for making decisions about whether or not someone should be released or held in custody after they've been arrested at the pretrial justice stage, to sentencing and determining for a judge what's an appropriate sentence or sentence length for someone, to where someone should be placed in terms of or classified in a particular prison, whether or not they should be subjected to parole and released early from their sentence. And so these tools really rely on kind of they rest on this notion that you can forecast someone's behavior based on historical data that may or may not be connected to that individual. And so what you basically do is compare a person to a cohort of individuals who have similar experiences, similar lifestyles, similar things going on in their backgrounds, determine what happened to those people, and apply the scores that you got from those people kind of to that individual and make a forecast about what that person who's standing before a court may or may not do. The problem, of course, is that the tools themselves are only really as good as the data that's fed into them. Mm-hmm. And if you think about American society, there's not a single aspect of our society that has not been touched by racial bias in some way, shape, form, or fashion. Every facet of our lives has something can tie back in some way to racial inequality. It is woven into the fabric of America. It touches everything from housing, education, employment, of course, all in the criminal justice system. And so these tools rely on data that is fundamentally flawed and fundamentally biased and fundamentally infected with racism. And in doing so, it's of course going to reflect back in the forecast you're making the same type of racial bias, the same type of inequality, the same type of racial inequality you see in the data that's being fed into it. So what you have is kind of garbage in, garbage out problem. You're putting garbage data in.
Just a scientific term, actually.
Yeah, it is, yeah, exactly. You're putting garbage into these tools, and you're getting garbage forecasts out. You're reproducing the same patterns of inequity that we already see in society. And so if you're reflecting society back, what of course you're going to get are predictions are going to reflect back those same inequities. These tools also, what they end up doing is encouraging profiling. So, you know, one of the, I think, the principal jobs of a public defender and a criminal defense attorney is to demonstrate why your client is different from everybody else. Why they don't deserve to be treated like all the rest of society or anyone else. Why they deserve to be treated like an individual with dignity and empathy and all the things that kind of are brought to bear about how you judge someone for what they've done, what they've been accused of, and their kind of life circumstances. What these tools encourage us to do is say, you look or seem or appear like everybody else in this cohort of individuals, and so we're going to judge you and treat you just the same as that whole group of individuals. So it encourages the very type of behavior that would undermine an individualized criminal justice system that we'd want in order to judge people with the type of dignity they're entitled to. The combination of those two problems, reflecting back the biases we see in the world and undermining this kind of individualized assessment of people, is basically an algorithm for perpetuating inequality, perpetuating racism, perpetuating the same biases we see in the world every day. The reality is these tools are being used, like I said, at every stage of the criminal justice system. They have been brought to bear, been kind of purported to try and reduce bias, reduce kind of concerns with decision making. But the reality is, and the effect is that we haven't seen any kind of effect across the country of these tools alone reducing racial disparities, reducing racial bias, kind of confronting the really fundamental problem that we see across the board. Part of that is a result of the people who are making the tools. So you have data scientists, people who have really kind of no social justice or very limited social justice understanding and understanding kind of our history. They approach these problems with the notion that you can kind of just turn a knob here or twist a dial here and resolve racism, which I think is a flawed notion to begin with. And then I think part of the problem is that as we kind of continue to use these tools and go down this road, how many of you have used your phone, like Google Maps, tell you to go somewhere, and you know that you should go in a different direction, but you just follow and trust the phone, and you end up being taking much longer than you would have if you just went in your own way. The tools kind of operate in the same way. There's this automation bias. You kind of trust what technology is telling you. You don't question it as much, and so it allows you to kind of perpetuate these inequitable decisions. An example kind of in the predictive policing context, two data scientists took basically drug arrest data and used it and fed it into a predictive policing algorithm that was used in Oakland, California. And when they fed the drug arrest data into the predictive policing algorithm, understanding that black and white people use drugs at about the same exact rates, what they found was that this tool would target people of color people of color were twice as likely to be targeted as white people for being possible perpetrators of drug crimes. That's just based on the data that's being fed into the tools themselves. And of course, the folks who are producing the data are police officers and law enforcement officials. And their data is being produced all based on kind of the historical biases that are driving where they might enforce the law, where they might choose a patrol, where they might choose to engage with communities. And so you have kind of this feedback loop where the data is telling you crime is happening in this particular place. You feed that into a predictive policing algorithm. The algorithm is telling you crime is going to happen in this particular place. You go back to that same place. What do? You make more arrests, tell you more crime is happening in this location, feed the data back into the tool. So you keep on getting kind of this loop of policing and algorithmic decision making, and it just perpetuates the same inequity we see in the world. It's also happening in pretrial risk assessment. People using these tools to try and forecast whether or not someone may or may not flee court or not show up to court, or maybe rearrested or engage in criminal behavior going forward. And the reality is that these tools don't really do any better than a coin toss when trying to predict who may or may not return to court, even though the reality is that the vast majority of people return to court regardless of what they're facing. And most people do not commit new offenses while they're being arrested, while they're being prosecuted for the offense they're being tried for. And so by and large, I think these tools have been ineffective, particularly at reducing racial disparities as was hoped, and reducing jail and prison populations, and in fact may be more harmful than good. Just think about it kind of in your own lives. You've heard stories about these like self-driven cars. They can't recognize black and brown skin, and so you have like these self-driving cars that like may run black and brown people over. You get like advertised to when you buy something online in your email, and all of a sudden you get ads for all types of stuff that's unrelated to the thing you bought, and you don't want
When
any
I
of these
say it
ads.
out loud and Alexa picks it up.
Yeah, when Alexa picks things up. And so you can imagine like errors in that space, and just layer those errors onto when someone's liberty is on the line. Or when someone's life is on the line. And that's the same thing we're kind of importing into the criminal legal system and just basically reifying all the biases we see going forward.
Yeah, and you mentioned the Oakland Police Department. I found that, and also with the New York City Police Department, that using data and relying on data to make decisions allows these departments who have had findings of racial discrimination to sanitize their conduct. So it's not us, it's not our racism, it's the data. And so that's an extra sort of twist on that phenomenon.
Yeah, I mean, you also have like, you think about police departments that are engaged in policing where they've been under consent decrees. So places like Ferguson, Newark, New Jersey, New Orleans, Louisiana, Chicago, the NYPD, all these places have been found to be engaging in racial profiling and found to be engaging in racially biased policing and misconduct. And they're using that very same data to inform what they're going to do going forward. That's deeply problematic, and we're just kind of masking it all with technology and the objective gloss of technology.
Yeah. ReNika, I want to return to you. You started with over 400 years ago. And as Vincent tells us, racism is entrenched. It's woven into the very fabric of this country. I know that your time at the ACLU is still relatively new, but if you can share with us some of the innovative things that the project is working on. How is it that folks at the ACLU are thinking about these issues, and how can lawyers, law students start to work on addressing and confronting some of this inequality that we've discussed?
Sure. So, I think, I was talking about pre-Civil War slavery, and then, we talked a little bit about the period immediately following the Civil War in terms of the passage of the 13th Amendment and this huge loophole for punishment where you're allowed to sentence people to labor. And really what you see is a shifting of the criminal justice system and the legal system from one that is intended to protect slavery to one that is trying to control and socially control, and really try to determine where limited resources with respect to whether education, housing, economic opportunities, jobs, that the criminal legal system is being used to distinguish those. And so I'm going to start by talking about sort of the ways in which we see the modern legal system operating, and then some of the ways that we at the ACLU are trying to target those different parts of the criminal legal system. So I'm gonna separate into three different parts. There's sort of what we think of as the state operated part of the criminal legal system, which is the police, the court system in terms of prosecutors, court officers, and then we have the prison system. So if we think of those as kind of the major parts of the state operated criminal legal system. And then we have the criminal legal system permeates private sector institutions, and that was some of what Michael was talking about in terms of educational institutions relying on criminal records. You have that in terms of access to voting, and you see this reliance on the information that is being produced by the criminal legal system to determine access to housing and can you get an apartment? Do you have a criminal record? And you seeing these other private institutions or non-criminal institutions relying on the information. And then you've got kind of private citizens who are able to use, and when you think about in the past few years, so we've seen a lot of these like cell phone videos where, or if you think of Trayvon Martin and George Zimmerman, where knowing the threat and the power of the police state, of the criminal legal system, are identifying who doesn't belong in a community, who shouldn't be there, who's too loud, who's wrong, and private citizens knowing that either a threat of a call to the police or an actual call to the police can result in them being able to impose, to exclude, or have arrested Black and brown folks who are in the community. So those are the different parts of the way that the criminal legal system operates. And so when we think about where it doesn't operate in the country, so I'm going to give you an example in terms of this. There are two states where folks who are in prison are able to vote, and those states are Maine and Vermont. And those are the two whitest states in our country. And I don't think that is an accident. They are 95+% white. And in many countries, you are able to vote even when you are in prison. And that is anomalous to the United States. And the intersection using the criminal legal system and the consequences of it to impose racialized disparities and impose racialized exclusions. So we're thinking about that at the ACLU. And so we're working on cases involving what we think of as these are called crime-free housing ordinances, and so that would be kind of in the private sector institutions using these. And so what happens is police get landlords to agree to impose these regulations that say they won't accept tenants or they will evict folks who have contact criminal activity, which can be broadly defined as calling the police for help. So that can affect domestic violence survivors. It can be if your neighbors call the police on you because you're too loud. And so we have litigation right now in Minnesota where there's a large Somali population and there's a rising African American population. And we see that the police are called on them disproportionately, and they're disproportionately being excluded from housing because of criminal activity. But when you dig deeper, that we're talking about arrests, we're not even talking about convictions, but just the stamp of criminality is being imposed, and then those exclusions you see. We're dealing with pretrial reform. One of my colleagues was testifying before Congress yesterday involving what Vincent was talking about in terms of pretrial detentions. And the fact that on the whole, and my colleague Brandon cited a statistic, it was less than 2% of people don't show up for court. I mean, it's really, this is, the fact of pretrial detention is addressing a problem that doesn't actually exist. So thinking about ways to make the default freedom before facing a trial and recognizing, and then we're dealing with
the intersection of class and race in terms of suspensions or imprisonment. So debtors' prisons, where people are incarcerated simply because they cannot pay court-imposed fines or fees. And then the suspensions of driver's license, which has become very common, and imposition of fines and fees on people who cannot pay and who are constitutionally protected in terms of there is a constitutional decision that says that you cannot deprive people of their freedom because of their inability to pay. And so we've just filed a lawsuit on Halloween in South Carolina, challenging the fact that they deny driver's licenses without providing an ability to pay hearing for folks. So those are some of the ways that we are thinking about in addressing the ways in which we see the criminal justice system operating, both in terms of the state-operated piece of that, but also these other pieces that extend the impact and the racialized exclusion and disparities that start as their source with the criminal legal system.
Yeah, and these are just very basic fundamental rights, the ability to obtain housing, the ability to drive. And in communities in South Carolina, you can't hop on the subway.
Nope.
To get to work, you've got to drive. And motorists in North Charleston, disproportionately Black and brown, are pulled over. And something tells me that folks whose license are getting revoked, it's a higher population of Black and brown folks.
Exactly.
Yeah. Christina, I wanted to turn to you and to discuss some of the ways that the Office of Appellate Defender is working on addressing, remedying some of these structural injustices that we've been talking about. And OAD is representing everyone out of the Bronx and Manhattan in state post-conviction, correct?
That's right. So I think we think of it in sort of three stages, right? Individual, organizational, and systemic. And so first and foremost, right, we are the public defender, we are the appellate defender, so we represent individuals, and that is that is the first and our highest calling. And so, right, our first obligation is to make sure that we represent everybody to the best of our abilities. But we do not just do that, right? We believe that that we need to do more than just go into court and write really great briefs and argue, eloquently before the appellate courts. We believe in holistic representation at the appellate level, and that means that within the first 6 months of being assigned to our office, someone is going to come up to visit our clients, each one of them, no matter how far away from New York City they may be. We go upstate, we visit them. If they are facing conditions of confinement challenges, we address them and advocate for them. If they are have a parole date coming up, then we do a full parole advocacy packet for them, and we have a success rate in the parole space north of 70%. So if we step in and we advocate for somebody, one of our clients on parole, the likelihood of them going home is extraordinarily likely. So on the first step, right, our first step is, right, all of our clients are Black and brown essentially, right, is to get people out. And then we want to keep them out. So we have on the backside, right, in addition, this is just over, right, representing people, right, on the backside when they come home, once we get them out on parole or when they come to us from prison, then we have a social worker ready, and we are working on education. We are working on housing. We are working on education. It is our goal to provide sort of a full service option that is an off-ramp from the criminal legal system, so people are not stuck in the loops that keep people trapped in the system. Second, organizational. Everyone on this stage knows, and I think many of you know, one of the challenges that indigent defenders have had over the years is representation, right? Public defenders have not always been, or organizations, and particularly I would say appellate defenders, have not particularly been the most diverse places in the world. And representation—
I think we're an exception here, this crowd
Exactly,
of PDs.
it is. It is, and everyone would say it, right? Everyone
Yeah.
on this stage would agree. Representation matters. It matters because when my clients say to me, and Vincent's client said to him, and Michael's client said to him, that they didn't trust the public defenders, and Alexis is like, I understood why, right? I understood
Yeah.
exactly why, because no one ever looked like them or sounded like them or understood the worlds in which they came from. I understand that, and I can only say when people say that to me, I understand what you're saying, right? But that is real, and that can't be ignored, and that has to be acknowledged. And we, as the Indigent Defense Bar, have to make a commitment to a real commitment, and I mean a real commitment, to reflecting the communities that we represent. And that is something that, I am committed to for my office, and I think it's something that other offices across the city need to make a deeper commitment to, and across the country as well. So we have to be committed organizationally to providing the kind of representation that our clients need and they deserve. But more than that, and part of that is also thinking beyond holistic representation, right? One of the things that we always lamented, right, at LDF was the denial, like the thing that we didn't have at LDF was data, right? And the thing that the public defender has in spades is data. And so for us as an organization, right, we want to be able to use the data that we have, use the information that we have as an organization, and tell the story that we know we have, right? To tell the story of our clients, to tell the story of Black and brown people in Manhattan and the Bronx, using real data, paired with, right, the stories that we're also telling. Right? And so that's an obligation that I think it is incumbent upon not just the trial defenders, but also appellate defenders should be using that data, turning it around, and providing the courts and policymakers with a real picture of what is going on in the court system. I think we also, and I think everyone on the stage will agree with me, I have heard growing up, and I know Michael probably has, and I'm sure Vincent has, growing up, I've heard people say that, oh, I do race work because I'm a public defender. That is not true. That is not the same thing. So, and you hear everyone laughing, and everyone here is quiet, like, wait, what? It's not. Because often what we do as public defenders is ignore race. Mm-hmm. Right? We think because we're representing Black and brown people, we are doing race work. But if you are ignoring the racism that you're seeing every single day in 100 Center Street, right? If you ignore the fact that the only people you ever see in that courtroom coming in through arraignments, new study, right? 90% of the people that go through arraignments in Manhattan are Black and brown, right? Then if you are not saying that out loud, that is not, standing beside someone that's brown is not doing race work. Right? Calling it what it is doing race work, right? The people on this stage who have said out loud in courtrooms across this country that what we are seeing is racism, that is doing race work. And we shouldn't be confused about that. And so it is incumbent upon us as defenders who are doing race work and who see the race problem to say it, to call it what it is. And to do it not just, right, as my organization, right, is not just in the courtrooms, but again, to tell the stories, to use the information, the data, right, as to advance policy, right? And that's I view it as part of my job as a defender, to take the information I have and transform it and push it out beyond just in briefs, right, in policy, right? I have to be talking to decision makers, whether it's a legislator or it is, right, the Department of Corrections, whoever it is, about what I am seeing to influence the way policies are made, because we are not going to change the criminal legal system in a courtroom, right? It is going to be a combination of courtroom advocacy plus legislative and policy advocacy, and we as defenders have to be part of that battle. So, right, we try to use all the resources available to us. And the last thing I think that's really important, because we all know the power of storytelling, we all know now the power of that we can get people to see, right, what we see, right? We now have video that shows, to some extent anyway, people's minds can be changed if you can see the things that we see. Right, and so I think I love the opportunity presented by restorative justice, right, and having sort of people sit across who have been, right, victims and offenders, sort of sitting across from each other and understanding and trying to come to real justice, not just like a win in a courtroom for me or for the prosecutor, but like actual justice for someone who has harmed and someone who has been harmed. So I think that's an opportunity that I am sort of thinking about how we can explore as an organization.
Yeah. And so much of what I hear from you saying is that we need to reintroduce humanity back into these cases and our clients and the victims who have been harmed in some of these instances. And it's what Vincent spoke about too, is that so much of our work is about bearing witness and lifting up, elevating the very human qualities and individual characteristics of our clients. In a way that the criminal legal system is trying to reduce them to a single bad act. Much of the work you talked about at OAD, because it's post-conviction work, is in contemplation that a client is released and returns into society, and ideally becomes a full citizenship again. And Michael, I know so much of your scholarship, so much of the teaching that you do deals with reentry. I know you've run a clinic on reentry. I think you're writing a book on criminal records. And when he gets back on the train. And so if you can talk about some of the innovative ways that folks advocating about reentry are getting things done and allowing folks to become full citizens again, even after a criminal conviction.
Yeah, and so it's similar to the point you just made about humanity, and I agree with you. That's one of the key ingredients that's just missing from just the advocacy, but also just from these systems. Right? These systems, to your point, Vincent, right? Vincent's point is that the criminal legal system is operating the way it is supposed to be operating. There's an irony in calling all these collateral consequences collateral, because these are the consequences that take over lives.
Yeah.
Right? Many people who've been through the criminal legal system will tell you that these collateral consequences ultimately are actually worse than the actual record. Right? And so part of it is, I think that the movements that have taken place have tried to raise up humanity. Mm-hmm. And what that means, and it's important, I'm sure you all may know this, and hopefully you do, but what that means is that we all have to be part of movements where the people who are the most affected are leading the movements, right? And that's what you've seen in the reentry space a lot. There are many organizations across this country, there are organizations who have really, truly pushed the needle, or organizations who are led by individuals who actually have direct experience in the issues they're confronting. And sometimes as lawyers, what that means you have to do is kind of take a back seat.
Yeah.
So I know in law school, you're not really taught to take a back seat, right? You're taught that as lawyers, you kind of know everything and can do everything. But there's a humility that comes with the urgency of the advocacy. So some concrete measures that have taken place. So I talked about education-related obstacles. So have folks here heard about the ban-the-box movement in the employment context, right? So in the employment context, recognizing the devastating employment-related consequences that are tied to criminal records, and also recognizing that these implicit biases that employers have mean they can't get past the question of race when they deal with criminal records. So ban-the-box means that employers, right, in states such as New York, and you have many, I think 25 states now have passed the legislation, 150 cities have passed the legislation, employers are not supposed to look at a criminal record or even know that the applicant has a criminal record until the applicant has either received a job offer or has advanced through the job process, right? The recognition is that hopefully at that point, employers get to know the applicant, the biases kind of maybe go out the window, and therefore they could still look at the applicant as just a person who deserves a job. Well, colleges now are starting to ban the box, right? There's an advocacy movement now afloat, and now, there have been there are a couple of states now that have passed legislation that require their state colleges to ban the box on college applications. Maryland is one of the states, and so what that means is a person with a record applies to college, doesn't have to say anything about the record during the application, and once the student is accepted, at that point, the student has to disclose the record, and the record doesn't disqualify you from going to the college, but it could mean that maybe you can't major in something, or maybe you can't live in this particular dorm, right? The SUNY system in New York actually has banned the box from its application, I think, a couple years ago. So that's one sort of next level, if you will, advocacy initiative, and so what comes to that. In terms of other issues, I mean, there's been a lot of advocacy in the employment context. So employment licensing is a huge issue, right? You have all these firefighters who are fighting these fires in California, many of whom are prisoners. Mm-hmm. And they've been doing this work since like the 1940s. This is not even new, right? So these individuals who have to go through training to fight these fires in California, when they come out of prison and they apply for EMT license, can't get the license.
Despite their experience.
Despite the experience and the training, right? And the fact that they actually want to do it and are great at it, right? There's lots of advocacy around pressuring licensing boards to not take a zero tolerance approach to applicants for licenses. There are a couple of states, I think North Carolina is one of the states that just passed a law that says there's a 5-year look back. So any conviction that's older than 5 years, you can't even be subject, can't even come in front of the licensing board. But also litigation is a response to that. So to Christina's point, one of the issues is that a lot of folks who come out of prison and they're facing all these obstacles don't have lawyers. I apply for a job, I can't get this license, I can't find a lawyer who's gonna file this appeal for me. And what's actually been found is that if a person has a lawyer and appeals these licensing denials, they're actually incredibly successful on appeal. So we need more lawyers doing that type of work as well. Record relief through expungement and sealing. Many states within the last 2 years have recognized the real burdens of criminal records and have passed laws that allow individuals after a certain point of time to get certain types of convictions off their records. Most states will allow, believe it or not, non-convictions to come off their record. You may say that's kind of curious, but in most states you actually still have to apply to the court, even to get a non-conviction off the record. You have to pay a court fee, sometimes you have to go in front of a judge. And so now the movement is going towards actual convictions. How can we relieve people of convictions? And we do see a number of states now that are allowing some type of record relief, particularly for misdemeanor offenses. And a couple of states are actually now allowing felonies to be expunged, but after an extraordinarily long waiting period, like 15, 20 years. So those are among the efforts that are taking place right now.
Thank you, Michael. In terms of data, it's not going anywhere. So the remedy isn't to turn and run from it, but how can we use some of these tools, some of this new technology to bring about and address this inequality? Bring about equality, address the inequality.
Yeah, sure. So I think, I think part of it starts with the kind of this fundamental recognition that racism in America is like a feature and not a bug, right? It's like the thing that's baked into the system. And so I think you have to kind of start with this kind of public education process for folks who are using these tools, who are engaged in developing, who are implementing them so they understand that fundamentally. And then I think it's really about a couple of things. First of all, putting kind of the people who are harmed by the criminal legal system to center your analysis. And so in that case, you would put the tools in the hands of those folks. And so the question I always kind of ask is, why don't we have risk assessment instruments to try and figure out like what judge is going to hold someone in custody illegally or when they shouldn't, or what police officers, when they go out on patrol, and engage in misconduct or are problematic and should be off the force or should not go out on patrol. So taking the tools and kind of flipping the gaze and aiming it at institutional actors who engage in misconduct and misbehavior and problematic behavior across the board and holding them accountable, the same way that you're trying to hold people accountable and forecasting what they're doing. And so I think, one example of this, Legal Aid Society has developed this tool called CAPSTAT. CAPSTAT was a tool that was a kind of tool that was used by the NYPD to try and figure out how to kind of track criminal behavior and determine where to patrol people. CAPSTAT is kind of a flip of that. And what CAPSTAT does is basically scrape publicly available data about police misconduct, police behavior, whether it's lawsuits, whether it's complaints to the CCRB and findings by the CCRB and things of that nature by the NYPD. New York has a very, very restrictive personnel records around what you can get in terms of how police engage in behavior and misconduct. And so what this CAPSTAT tool does is scrape all that information and provides it to defense attorneys, to advocates, to people who are community members who are engaged in advocacy around policing and police behavior, and provides that information about when officers are engaged in misconduct, which precincts are problematic, what pairings of officers might be problematic. It's used to fight back kind of against police misconduct during trials and things of that nature. And so using that information is in a kind of proactive way to hold these actors accountable. It's kind of one of the more novel ways I think technology has been used to kind of to try and turn back the tide or confront some of the bias and inequality we see in the world. I think the other thing that I think about kind of in this space is really some of the things that Christina was talking about, others were talking about as well, is like shifting our focus from these like kind of numbers-driven decision-making to really digging into people's identities and narratives and individualized determinations about what people should be subjected to. We've sung so far kind of to one side where we kind of are willing to paint people with a broad brush rather than taking the kind of the time to really think through what's going to be best for an individual and what's going to be most helpful for an individual, kind of turn themselves away from the criminal legal system or out of the criminal legal system. And so I think kind of dispensing with this notion that we have to kind of boil everything down to a number and to a data point and thinking more along kind of the lines of an individual and using the tools to hold decision makers accountable is kind of one of the ways this technology is going to be used for good, hopefully.
Yeah, thank you. ReNika, you want to weigh in?
Yeah, and I was going to say, I think one of the other things that we're doing too is, which complements the point that Vincent's making about seeing the individual, is that there are ways in which the system operates where it assumes that there won't be the most intensive restrictive hold, and it's just not for Black and brown folks, right? And so you don't have to look at the individual if you start from a place where, like, we're going to assume we're not going to hold these people, because then you don't need to actually look at individuals. And so one of the things that we are also trying to do in our work in talking with companies that are using AI to determine, who gets, who's allowed to use the platform, who's allowed, is to say that for criminal records, we recently settled a case down in Virginia involving a development in a housing development just outside of Virginia that was relying on criminal records. And what we said is that in general, you shouldn't be looking at criminal records except in these very specific circumstances, because we know that for the past 20 plus years, the criminal legal system has been unjust. And so most of it is actually going to be irrelevant. And if we think about why arrests are made, if we think about why folks are in contact with the criminal legal system in the first place, then we can actually disregard this is to Vincent's point of garbage in, garbage out. And so really tightening down, there are only a few crimes that might be relevant for a short period of time, and really everything else should not be used. And there's a quote that I heard a long time ago that I think is particularly relevant in the data and AI space, which is that not everything that can be counted counts. And just because you have it doesn't mean you have to use it or that it is useful. And so we are also trying to push back on what the defaults are. Like, the default is that people should be released. The default is that most of what is in a criminal record should not be used and wasn't used for like a long period of our country's history. And so there are only very specific circumstances where it might be relevant, and really getting companies, getting other actors to start from a different place.
Yeah. I think I think of that, like, that notion as kind of almost like a digital reparations of sort. If you think about these tools as like a mirror, when you use a mirror and when you wake up in the morning, you look in the mirror, you like adjust what you see, and that adjustment is all kind of a matter of our own will and like what we want to do. And so if you think about like the society we want to have and build tools around that rather than kind of building tools on top of an already jacked up society, then I think that'll kind of advance the ball in a lot better ways. And this is 2019, like, there are ways that we can kind of confront the bias and the racism in the data and take stock of it and acknowledge it and adjust accordingly, rather than just kind of acting as though it's there or acting as though we can scrub the data of it, which I don't think we can do.
Yeah. We've got time for at least one, if not two questions from folks.
Sure, it's the plaintiff. So in the case, we represent 2 African American women as well as 3 Somali refugees who settled in the town is called Faribault, Minnesota. And so we represent them, and we've brought equal protection claims, but also we brought Fair Housing Act claims in terms of discrimination, and then some state claims that parallel the Fair Housing Act is sort of it's like a state human rights anti-discrimination bill as well. And so so we're challenging the crime-free housing ordinances. There's also some recent ordinances they passed about size of household that we know are targeting. The Somali community tends to be have bigger families, more children. And so we know, and what we've really done is dug into the record of what the history of the city that passed the law. And so you see these discussions that there's no crime, like that the reason for the crime-free housing ordinance is given, is originally that there's increased crime or to address crime. And there's clear discussion of the fact that crime has actually been going down. And so there's really no basis. And this cover of criminality has, been used through for a very, very long, going back to maybe not quite 1600, but in the sense that criminality and that label is used to deal with general things that make people uncomfortable. And so I think that's another piece where we question, like, what are we using crime, criminal to stand in for? And often it's something else. It's either like, well, they're not like me, they're poor, they're this, they're that. And that's the way that we deal with, general tensions within a community that still need to be addressed, and there are ways to address those, and that goes to the restorative justice point. But not invoking the state and not excluding people from basics like housing and schooling and education. But that's, if I've answered your question about the case, but happy to provide more.
Other questions?
Thank you all for being here. I was really interested in Christina's point about calling out race work and calling out racism when you're working in Black and brown places especially. And I feel like, there are a lot of young people in this room who are going to go, who may not have the opportunity to work in a place that has an affirmative commitment to racial justice like LDF or RJP, but may have the opportunity to work in the court system or represent indigent clients or clients of color. And I just wonder, particularly for folks who maybe don't have the same political or professional power as they're just starting their careers, how you would suggest we go about calling out racial inequities in positions where we're kind of surrounded by what we understand as racism and see as racism, but maybe don't have the power yet to actually affirm it.
That's a great question. So what I don't recommend is to call everything.
He's headed to LDF this summer.
Oh,
Yeah.
what I don't recommend is calling everything right. Everything is not racism. So that's the first thing, right? Like, so it's you have to be, first of all, precision and right about what you're calling racism and when you're naming something as racism. But I think I have raised race throughout my career, even long before I argued in the Supreme Court, right? I've worked in offices that I thought did not.
Christina is rarely at a loss for words.
I'm trying to carefully phrase.
Didn't essentially embrace it.
It wasn't quite handled as well as it could have been. Issues of race were not handled as well as they could have been among
Very diplomatic.
the staff, on the staff level, which I think is often a place where that plays out, right? Promotions and the things like that. And so for a while, like you, I was like, well, maybe I shouldn't say I see things, but maybe I shouldn't say anything. I see things. And at some point, I just said something, right? And so I don't, and it changed, right? And things changed. And did they fixed? No, right? And incremental progress, right? These are big problems. So I guess my first point is to say, while I do not suggest, encourage, or recommend that people just start, screaming racism, but what I do want to be clear about is that you have more power than your question just suggested, right? You know what you see, right? And if what you are seeing is different treatment, right, along racial lines, then you should call out what you see, right? Supported, right? We're lawyers, right? Supported by facts. That doesn't you don't have to argue in the Supreme Court to do that. Whether that's the judge, for example. I had a judge when I was a baby lawyer in Manhattan. I was doing arraignments, right? We're doing arraignments, and people are going in and whatever. And then a non-Black person came through, and it was like the whole world had to stop. The one non-Black person came through arraignments, and it was like, oh, Lord Jesus, what have you called? Where is his family? How is this going to happen? We get this, please, Lord, get this man
Make
some
sure the
help.
court reporter is here.
Right? It was the whole world had to stop. And I was so offended. I was so offended, right? Because the people who had come through that looked just like me, like my dad, there was nothing, there was no concern for, you know? And so I said it. I was like, with all due respect, right? Like when the gentleman that came before, you know, that looked like me, that we didn't see, he got very angry. But you know, what's gonna happen, right? It was true, right? And so don't discount your power is my message, and you all should jump in.
Yeah, I mean, I agree with that 100%. So first of all, I think that sometimes you may be surprised what an office will let you do, even if they don't do it themselves. Because they may say, oh, thank goodness.
Yes.
You want to run with this? Like, you want to expand the representation in a way? Finally, we have some, go ahead and do it, right? They actually may give you that. They may just, selfishly, they may allow you to do that. But also just even on a more concrete level, I mean, in terms of exercising your power, there's so many different spheres of power that exist even before you get to court. So just as an example, if you're a public defender and you were negotiating with a prosecutor, well, I'm not going to say it's the case now, but it was my experience that prosecutors also had this deficit of not understanding who our clients were and where they were from. And as a result, you know, there could be many assumptions about not only who your client is, but where he or she was hanging out. So whether something's a pool hall versus an arcade, which actually came up in one of my cases. That's the one I remember. So the point is that, you know, I think our job is to try to educate everybody about these issues, all right? And that includes your adversaries, people in your office, whomever. And so there's different ways I feel that you could try to assert who you are and assert your voice in these different dimensions.
Okay, thank you. And I see that it's 2:00 now. I know that we could easily continue this conversation for hours, but I think what's clear is that the criminal legal system is a fertile area of the law that could use some creative thinkers and can use some innovation. And so I encourage all of you to explore working within this system. Beyond being a public defender, although that is a dire need.
That is the best way.
Yes, and that's really where almost all of us started. But I hope what's
There are other ways too.
yes, but I hope what's been made clear is that this is a part of the law that could use your creative legal minds. And so if you'll just join me again in thanking our panelists, this was fantastic. And if you wanted to continue this conversation, I'm sure Vincent will give you everyone's contact information should you request it. Thank you. Happy Friday.